Yours too.
All right, we're going to go back on the record in NIMAC number 760861, Vincent Alfonso Jr. If I could have parties re-announce, please, for the state.
Will Brooks for the defendant, Mr. Alfonso Judge.
All right, and you're Mr. Alfonso.
I'm Alfonso Vincent.
Okay. All right, so where we left off is whether or not the defendant has been in custody past the 90-day mark. And defense?
Judge, he is at 94 days in custody.
Okay. All right, so he's entitled to a bond that he is able to make. And so the current bond is at $15,000. And I know we started, but do you wish to call your client with regards to a bond amount that he's able to make?
If I may for that purpose, Judge.
Yes. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Alfonso Vincent.
You may proceed.
Alfonso, the court has to make a determination as to whether to reduce your bond or potentially give you a personal recognizance bond today.
Yes, sir.
So I'm appointed to represent you, correct?
Correct.
Do you have the ability to make the bond at $15,000?
No, sir.
Do you have bank accounts?
No, sir.
Do you have cash?
No, sir. I've been locked up.
How long have you been locked?
I got locked up April 3rd, so it's been over 100 days.
And is there any family member, or anybody that's able to make the bond at a current amount?
No, I'm not from here.
Is there any amount of bail that you or a family member could make?
Not sure. I'm not sure.
But as it stands right now, you're incarcerated. You have no money to make bail.
Right.
And no way to make it.
Right.
Thank you.
All right, any questions with regards to bond amount? State? All right, I just have a few questions. So have you ever been diagnosed with any mental health issues?
No, ma'am.
Have you ever been on any type of medications?
For mental health?
Yes.
No, ma'am.
Have you ever been on any type of medications for medical reasons other than mental health?
I'm a diabetic.
All right. And any drug use?
No, ma'am.
All right, thank you. All right, state, what are you requesting? All right, defense?
Judge, I'm just asking for the court to consider a personal recognizance bond. If not, then to consider the state's request.
So what I'll do is I'll set the bond at the bond amount requested by the state. This one. We don't have the order attached, but I'll write an order. All right, I'll set your bond at $1,500. Any conditions being requested by the state?
Judge, my only issue with that is, should he make bail, my expectation is that he's going to be picked up by law enforcement and transported to Dallas County. So my worry is that stops that from happening somehow.
Okay.
But I mean, maybe if the court would order within 7 days of release.
All right, I'll do GPS, waive fees, and GPS. I'll order full GPS, waive fees. GPS to be installed. Within 3 days of release from custody. And counsel, if for some reason he's immediately transferred to the other county, just let the court know.
Understood, Judge.
And then that may change the court's order.
Okay, thank you, Judge.
All right, is there anything else? You're welcome. All right, Ms. Ferguson, on Mr. Alfonso, just give him a court date in 45 days.
Yes, ma'am.
Thank you.
Thank you, Judge.
You're welcome. And if you'll give him the reset form.
Yes.
All right, thank you. All right, Alexander Castro. Yes. All right. So on this case, who's going to be the attorney who's actually trying this case?
It's gonna be me. I'm gonna be one of them, Your Honor. I think someone else might be listed online, Judge, but I think that's just the name that the clerks grabbed from the notice of appearance. But I'm the lead on it.
All right, Norma, set this for jury trial. How long is this trial going to last?
3 to 4 days, Judge. At least.
Yeah, week. Right?
Okay. Norma, it's 2022 CR 11862. And then we're going to go on the record with regards to this motion to continue.
And I'm sorry, because you were asking what date?
As soon as we have a jury trial date available. They say it's gonna last like maybe 2 days,
Judge,
It's
I
gonna
said
be 5.
3 to 4 minimum.
3 to 4 minimum. So I guess that puts us at the week of August 12th. Oh, wait a minute. It says he's gonna be gone.
I'll be on vacation, Judge. I'll be out the country.
What date do you all want?
I mean, sooner rather than later, Judge. We're ready.
Oh, okay. Okay, so do y'all want to do it on August 19th? I know that's towards the end,
Just what day of the week is that, Judge? Is that Monday?
Monday.
I'm good with that, Judge.
Just 1 second. And then we'll go on the record on this motion for continuance. Court is calling 2022 CR 11862, State of Texas versus Alexandra Castro. Can our parties announce for the record for the state
Daniel Escobar for the state of Texas.
defense?
Gary Hilly for Mr. Castro.
All right, your client is not present. Are you excusing his appearance for this hearing?
Yes, Judge.
All right, counsel, you filed a motion for continuance. State, do you have any objections to the motion?
Yes, Judge. We can post.
Okay. All right, so this is set for jury trial on July 22nd. And are you both ready to go? State, are you ready to go on July 22nd?
State's ready.
You want to present your argument as to why it shouldn't go on
Yep.
this date? Because
Yep.
this date has been set for a while.
Yes, Your Honor. I have got a professional one and a personal conflict that comes from the professional one. I'm registered to take the board certification exam on October the 1st. And it's not a requirement, but it's recommended that you attend the advanced criminal law CLE, which starts It's actually in San Antonio next week.
Mhm.
It starts on Monday, so I'm registered for that. I filled out an attorney unavailability online with the county for that, and that's my professional conflict, Your Honor. That's caused me some personal problems as well. If I have to go to trial, I don't really want to put that on the record.
Oh, yeah. Okay.
All right, just one second.
And we're, cognizant this is a 2022 case, Judge, and we want to try it as well. And we're respectful of the court's time and docket, but we just very respectfully ask for a short continuance.
All right, then we can set it on July 29th. Are you, both parties okay with that?
Yes, sir. Obviously, we'll modify the witnesses, but I believe that we would have to have contact with all. We're okay with it. That's.
All right. So we're gonna go on July 29th. All right,
Well,
and
trust, Judge.
your
Thank you.
motion for continuance then will be granted.
Thank you, Your Honor.
You're welcome.
May we
And
excuse
you'll
me?
like to, you have to let your client know.
We'll do, Your Honor. We'll meet with them anyway.
All right.
And is he excused for next week then, Your Honor?
Yes,
Thank you, Judge. May I be excused?
yes,
Thank you, Judge.
you're welcome.
And it's with the special prosecutor. So we have to wait for us to come here, but I told him that I'm ready.
Judge, I'm assuming, you said that the 29th,
Ninth,
but I'm assuming if we're still gonna do like, is it gonna be board ire and stuff on Wednesday or on Tuesday?
yes.
Okay.
Yeah. All right, and if you all can make sure, let me double check. Oh, yes, the acknowledgement of discovery is in the file.
We'll probably be updating that also.
All right, thank you. Okay, all right. All right, Norma, if you'll put this on the 29th then, okay. And Jason. And I don't know if this family violence or criminal trial division. All right, who's here on Jennifer Wilbur? All right, if you'll come forward, please. Hello.
Hi.
All right, court is calling 2024 CR 067462W, State of Texas versus Jennifer Wilbur. Can I have parties announced for the record for the state?
Christopher Ramos for the defense.
And are you Miss Wilbur?
Yes.
All right, Ms. Wilbur, did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure with your attorney? Did you understand it?
Yes.
Did you understand that by entering this plea bargain agreement, you are waiving the right to have a grand jury hear the facts in this case and make a decision on whether or not to hold you over for indictment?
Yes.
I'm sorry, hold you over for trial. Did you understand you're also waiving certain rights that your attorney has, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial?
Yes.
Did you understand that by entering this plea bargain agreement, you were giving up those rights that I've explained to you? And counsel, did you explain this document to your client?
Yes, ma'am.
And Ms. Wilbur, did you sign this document?
Yes.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information, and rights under Article 1.05 and 26.03 of the Code of Criminal Procedure. Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes.
Did you review the information with your attorney? Did you understand it?
Yes, it is.
Counsel, do you waive the reading of the information?
We do.
State, are you proceeding on the information as presented?
Yes, Your Honor.
Did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it?
Yes.
Did you understand by information, you're charged with possession of a controlled substance, penalty group 1 gram to 4 grams. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? And did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does.
Do you believe she's currently competent and was legally sane at the time of the offense?
She is, and she was.
Ms. Wilbur, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, there's a $1,000 fine to be probated. State is recommending deferred adjudication. This is to run concurrent with 716927. They will take in consideration 723334. There's to be restitution of $5,139.17 and cause number 72334 to Teresa Shields. Did you understand that to be the plea?
Yes.
Defense is at the plea.
Yes, ma'am.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been such motions?
No, ma'am.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. There be a TAP evaluation and 120 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged in the information, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
No objection.
All right. Did you review the document? State, you may be excused. Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney?
Yes.
Did you understand it?
Yes.
Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. Right, after reviewing state's exhibits 1 and attachments, court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
Yes, ma'am. I can offer that. My client, earlier this year, she participated in the Pay It Forward program at the Hope Residential Center. She began that program in February 2024. She was released from that program and completed it in the spring. That's when I met her. Around that time, I received information from lifetime recovery counselor, Ms. Kelly. She provided information to me and she described Ms. Wilbur as having a better understanding of what substance abuse is and how it's disrupted her life. Ms. Weber is currently also participating in receiving services with the San Antonio Council on Alcohol and Drug Awareness. She's been associated with that program since April 24th, 2024, and her recovery coach writes that Ms. Jennifer is doing very well on this program. So it does seem that as early as earlier this year, she's been doing very well, doing her best to get her hands around the substance abuse issue. And we anticipate good things from Ms. Weber as she continues on this deferred.
Okay. So, do you have any family support in San Antonio?
I do. My dad's here with me and I have my daughter, my sister, my brother.
Okay. And do you stay with them or are you staying at Lifetime?
No, I'm staying in a sober living dorm.
Okay. And are you employed?
I am.
And what do you do?
I work at the front desk for a hotel downtown.
Okay.
And that's a brand new job for her. She just got it.
Congratulations.
Thank you.
That's all. Jobs can be stressful because when you're at the hotel, sometimes people are upset that the room is not ready on time and all of that,
Yes.
but I'm sure you will handle it well. All right. Do you have any children?
I do. I have one. She's going into college in the fall.
Oh, awesome. All right. This is what the court is going to do. Court is going to sentence you to $1,000 fine. That will be probated. 4 years deferred adjudication. If you complete everything early, the court will consider releasing you early. This will run concurrent with cause number 716-927. Taking consideration 72334. There's to be restitution to Teresa Darlene Shields, SHIELDS, of $5,139.17. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. She's to continue living in the sober living house. We'll do a TAP evaluation out of custody. Probation, if TAP recommends inpatient treatment, we'll start with outpatient treatment. Are you doing any sober meetings?
Yes, I do 5 a week.
Oh, that's good. All right. So here's the thing about sober meetings. I always require sometimes, not always, but sometimes I think I see people and I'm like, you need to do sober meetings. So what I'm gonna do is I'm gonna place you at 4 sober meetings a week. If you want to do 5, you can do 5. The fact that you do more than the sober meetings that I'm requiring of you is not going to be a detriment to you because your goal in this probation should be finding out what you need to do to maintain your sobriety. And if taking 5 a week means you maintain your sobriety, it's not going to hold you back from early termination, okay? So there's going to be 4 sober meetings weekly. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Probation, there'll be 1 field visit just to find out which sober living place she is. And then thereafter at probation's discretion. 120 hours of community service restitution. Probation, is there anything else? Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. Here's the thing. Just give me 1 second. In this courtroom, communication is key to be successful. If you ever think that you're gonna use, pick up the phone, call your probation officer and say, I'm thinking about using. And then that way probation can get you some help. If you call and there's no answer and they're not addressing it, you can always come back to the court and address it with me here Monday through Friday, okay? All right, good luck to you. All right.
Thank you, Judge.
You're
May
welcome.
we be excused?
Yes,
Thank you.
well, once probation goes over,
Yes, ma'am.
yes. All right, who is on Alberto Hernandez?
Bring that in honor for Monica Gennaro.
All right. Deputy Laura, can you have them move to the other end?
A little more closer, and when you speak, make sure you speak loudly and don't say, don't nod your head, make sure you say yes, no.
All right, court is calling 2024 CR 4387, State of Texas versus Alberto Navidad Hernandez. Can I have parties announced for the record for the state
The honor for the state.
defense?
The attorney record is Monica Guerrero. Joseph Stateson standing in to cover. And Mr. Hernandez, will you give this court permission for me to do this in place of Ms. Guerrero?
Yes, sir.
All right. And you're Mr. Alberto Hernandez?
Yes, ma'am.
Counsel, have you received all the discovery that you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Hernandez, did you review what's entitled application of community supervision with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, ma'am.
Both counts?
Yes,
Did you review the document entitled Court Admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Let me see. All right. Did you understand in each count you're charged with online solicitation of a minor as a third-degree felony?
Yes, ma'am.
Range of punishment in each count is anywhere from 2 to 10 years in prison and up to $10,000 fine.
Yes, ma'am.
If you have a plea with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you are giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishments to be assessed at 8 years in the prison. There's a $2,000 fine. There's no application for deferred adjudication, and the state is opposing your application. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea.
Yes, Your Honor.
State is at the plea.
Can you repeat it one more time, Your Honor? There was some clarification Mr. States and I were talking about earlier.
All right. It says punishment to be assessed at 8 years. There's a $2,000 fine. There's no application for deferred adjudication, and the state is opposed to the community supervision.
Yes, Your Honor.
All right, did you review the paragraph entitled waiver of appeal paragraph with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motion?
No, Your Honor.
Then to count one, how do you plead? Guilty, not guilty, or no contest?
No contest, both.
To count two, how do you plead? Guilty, not guilty, or no
No
contest?
contest.
State any evidence to support the plea?
State offers State's Exhibit 1 in all attachments.
No objection, Your Honor. My client's asking a question. Can I
Yes.
step back just a moment?
Sure.
We should be fine. We'll get the signs.
All right. Did you review the document entitled waiving consent to stipulation of testimony and stipulations with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports?
Yes.
But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, so my question. With regards to count 1, maybe I'm missing it in the documents. I see evidence of count 2. And so I'm just trying to find the evidence in there of count 1.
And Your Honor, may I put something on the record at this time?
Yes.
I had explained to Mr. Hernandez, chapter 62, sex registration.
Mhm.
And how online solicitation of a minor in chapter 62 is a reportable conviction.
Yes.
It requires registration. Although the plea bargain page does not indicate that, it's an operation of law that would be
Yes.
effective. So I just wanted to let the court know, we did discuss this. I did admonish Mr. Hernandez, and I explained that he would have to register. That's part of the plea, even though it's not actually on the plea bargain page.
Oh, thank
God
you.
bless you.
Mr. Hernandez? I haven't mentioned the chapter 62 registration because I have to see the evidence first. And so once I see the evidence, if I find that it is sufficient to find you guilty, then you will be required to register. Okay.
May I step back a moment with the prosecutor also?
Sure.
Regarding the
And it's regarding the statement that is in count one.
statement count.
You can have a seat if you would like while they search for that information. It's the question that's in count one. I don't see it in any of the steps. Yes, thank you. Oh, I just like it. Thanks.
Judge, may I briefly approach?
Yes.
Directly for the final.
Yeah, family violence, making things happen. Is this on the docket for today?
Yes, it is,
Oh,
Judge.
could I see the file on Marie Miles?
Yeah.
This one, I didn't move the calls. Yeah.
You know, actually, I think she's on the docket as,
Might have been set for a plea.
yeah, Miara.
Oh,
This
it's
is
Miss
like
Bell.
Miles. Who is Miles?
So we
Is it
have. both on the end of-
MILES is the last name.
Yeah, that's what I have. on-
on here? On the docket, it's Marie Therese Miara.
Okay, that's not right.
Well, I checked the indictment, it matches our file. Sure. Indictment's right.
But Norma, she's on page 3 of the docket as Marie Therese Miara.
33. Let me go to see you back to.
All right, so who is this?
In person.
All right, Deputy Lawyer said this is the same person, Norman, so I think that's what you have.
I asked her.
I have it on the docket, but I don't have a file at all.
Oh, not for this one?
Yeah.
Okay.
Let me look in the back.
All right.
I don't know. But I had a client just a couple weeks ago, we pled out and he was entered as, his last name was Garcia.
Mhm.
And it was entered as Garcia.
You know what comes to
Did I
my
ever
mind?
find that in Odyssey, by the way? I would never have known his name was, I could never like figure out misspellings and find a person.
You know what comes to my mind? The series Secret Agent Man, you know? He doesn't know the song, but you know the
Yes.
song.
Oh, what a famous song that one is.
He doesn't know.
Love it. Oh, classic.
So now it's just running through my head right now.
Oh, you beat me to it. Judge beat me to the
Yeah.
tune and everything.
Oh, he still doesn't know it.
He does not.
It reminds me of my childhood, Judge.
He probably never saw the Jetsons either.
I know the Jets. Come on now.
I'm still disappointed we're not riding in cars, flying.
I know. A lot of it though.
Yeah.
I remember, I mean, Bewitched, that one of the things was pushing a button and turning things on and like,
Yeah.
guess what? We push buttons and
When
turn
everything
things
has-
on.
And I knew that reference too. I would wiggle my
And I
nose
bet
if
you
I
know the
could.
77 Sunset Strip either, do you?
Oh, my favorite address.
Ah.
Bear County.
Looking for the file.
Oh, and Judge, he has not seen the Christmas Story.
No, I have. No. That is.
He pretends he saw it, but he has not watched
That is just sad on a
No,
whole
that is
different
not true.
level.
it. He thought the red flyer was a wagon.
See what happens?
Okay.
I gotta fight defense attorneys and staff.
All right, so Lorraine,
Is that-
you need to make sure that you check the system because on the docket, it's Miara
Okay,
and
but the indictment, the name of the indictment.
Miss Miles, come forward. But she answered, when I called the docket, she answered.
Yeah,
it.
yeah, she. usually-
Miles, come forward.
But you just looked up her AK.
What, Miles or Maria?
Miles.
Miara.
I have Miles.
That's the AKA?
With him.
Oh.
That's her middle. Marie.
All right, so what's your full name?
My married name was Marie Therese Miles, but I did notice when they arrested me a year ago, when they gave me the inmate card, it said Nyaha on there for some reason, but it's my maiden name. I don't
Okay.
know how they
Your
came-
maiden name?
My mother's name.
Oh, not,
All right.
I thought you said middle name.
So here's the thing, state has filed a dismissal. The reason why they're dismissing it, they're not saying that you didn't do it. They're saying they're dismissing it because the complainant in the case has waived prosecution. So I don't know anything about the facts of this case because I would only know about that if the motion to suppress was filed or if you all were in a jury trial. So what I can tell you is this is a family violence case. Whatever issues between you and the complaining witness that brought you to court today, whether they wanted this case dismissed or not, those issues are still there. And they're gonna rear their heads when this case is done and you and the complainant leave, if this was that type of relationship and go home, those issues are still gonna be here. So you all maybe wanna go to therapy to figure out what your issues are. And then you need to make a decision. Do you want to stay in a relationship like this or not? And if the answer is no, then people need to part ways. Because I'm a firm believer, anytime you're in a relationship, when people want to start putting their hands on people in violence or whatever, maybe it's time for that relationship to be over. And when people think that people are cheating on them, you have two choices. You either accept it and stay in the relationship, or you say, thank you, I think you're cheating on me, the trust is gone, this relationship is over, and move on. Those are your choices. So here's your dismissal, and hopefully we don't see you back for this again.
And I don't think you ever will. But thank you,
We're
Judge.
gonna put you on the record with that.
Thank you.
You're welcome.
Some confidence.
I do too. I think she's gonna be fine. Good luck to you.
Thank you.
Oh, and it's raining outside. Oh, it did? Awesome. All right, are you all ready on Alberto Hernandez?
Yes, Your Honor.
So were you all able to find what I could not find?
States amended States Exhibit 1 and has presented it to defense counsel for objection.
I reviewed the additional, I believe it's 3 pages. It would substantiate the count 1, the evidence. The evidence, it is what it is. I know that there's text and graphic picture. It is part of the offense. That is the stipulations, and we don't object to the stipulations.
All right, I'm assuming it's amended where the green tab is that correct?
It's the final 3 pages, Your Honor.
Okay. Okay. Well, I didn't need the last picture, but okay. All right, after reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty of count 1 and guilty of count 2. And we will come back on September 12th. At that time, the court will make a decision on your application for community supervision. That will be based upon any evidence that is presented to me and also the PSI report. Is there going to need to be a TAP evaluation as well or no?
At your discretion, Your Honor, I don't believe substances were involved in this offense, but if any additional evaluation could be helpful.
All right, we'll do a PSI and TAP evaluation. All right, once you speak with probation and sign the reset form, you're excused.
Thank you, Judge.
Ma.
All right, you're welcome.
Yes.
All right, who is here on Nelda Rios? And where's Miss Rios? Court is calling 2022 CR 11792, State of Texas versus Nelda Rios. Could I have parties announced for the record for the state? Defense?
Albert Chidas or Ms. Rios?
Are you Miss Rios? All right. Are there any applications in this case?
No, they're not.
All right, Ms. Rios, did you review the document entitled true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right. Did you review the document entitled Court Admonishments with your attorney? Did you understand it? Did you understand, by indictment, you're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram. It's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand by entering this plea, you are giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Rios, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? All right, according to the plea, punishment is to be assessed at 14 months in the state jail facility. There are no applications. The state will take in consideration JN number 6785865. Did you understand that to be the plea? Defense is at the plea?
It is, Your Honor.
State is at the plea.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? State any evidence?
No objection, Your Honor.
State you may be excused. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. And the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just that she does have approximately 329 days for county jail credit. We would just ask to have credit for that.
All right, so, and I'm sorry, Ms. Rios, you entered a no contest plea, correct? Okay, I'm sorry, you were whispering, it was hard for me to hear. So, do you have a place to live when you're released?
I'm homeless.
Huh?
I'm homeless.
All right, so what are your plans? I mean, there are places that you can stay. There are sober living places, because obviously you have drug issues. So have you looked into that?
Oh, just like God take me.
All right, so here's the thing. I understand when people say they're gonna let God take them where he wants to take them, but God gives you senses, right? And so you got to do your part. There's a story that people always tell where somebody was drowning. and somebody came by in a boat saying, hey, let us help you. You remember this story?
Yeah.
And the person like, oh no, I prayed, God gonna come save me. Then helicopter. Oh no, don't need any help because God is gonna save me. Person ends up drowning. And it's like, God, why didn't you save me? And it's like, I sent you the boat, I sent you the helicopter, I sent all these people to help you, and you didn't want it. So you're gonna have to do your part too. And there are places where you can go for free. When you're released from custody, if you can't find those places, you can come back here. If I'm still here, I'll tell you the different places you can go. They even have a community court that can help you with housing. But this location where that person told you leave and not come back, you can't go back there. You understand? All right, the court, as previously stated, is finding you guilty. The court will sentence you to 14 months in the state jail facility, give you credit for any time served, taking in consideration JN 6785865. Yes. And there is to be no contact with the Ariba, ARRIBANEN, Blanco, BLANCO apartments at 5200 Blanco Road, San Antonio, Texas, 78216. And I request the therapeutic community will not increase the time that you are in custody, but hopefully they can help you maintain your sobriety when you're released. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. You're welcome.
Thank you, Your Honor.
Okay. Norman, can you call Arlene Gay on Naomi? Okay.
Please.
It's not the same. She put through
Huh?
and once it goes on, go through the chief's office.
Okay. All righty.
And I did look it up where he's gonna be going. It's not a Colorful City, it's like the neighbor's experience or what's the name? You know, there's the address.
Okay, all right, thank you. All right, what we're gonna do is we are going, State Naomi Hernandez. Hi, we're gonna recall you, okay? We're gonna recall you for August 1st. My understanding, you have a setting scheduled in Judge Carruthers Court on evaluation, so we'll see what happens there.
Was that?
It's Naomi Hernandez, sorry. Yes, you have an evaluation with Judge Carruthers on Friday. It's, your attorney will probably be best to explain that to you. But I think it's best that you have that evaluation done so I can make sure that you understand everything, okay? But it's gonna be a quick turnaround. That hearing is for July 26th, and then I'm gonna bring you back to this court on August 1st, or maybe even sooner if your attorney requests it, okay? All right, thank you. Okay, all right, you'll need to talk to your attorney concerning that, all right? All right, can I see the file on James Ross? And then I'll be ready for you, Mr. McClain. And I need that one, and I need Israel Medellin.
Mr. May.
I think he's in federal custody.
Okay.
No, just have a seat. Just 1 second. I also need the, oh, that's, he's for Kelly on that one. Just 1 second. I'm going through what's left. Oh, James Ross. Okay.
Oh.
And I need to see Michael Mora.
That's a cute cartoon.
Jason, can you double check? Is Israel Medellin in federal custody?
That's, saw that on there. Is that a?
Okay.
Let me check on that, Judge. I might have it on my email.
Okay, thank you.
And Jason, your daughter will like that.
What?
Your daughter will.
It's cute.
Okay, and let me give you this one because Michael Mora is actually set on September 10th. Norma, Michael Mora is supposed to be on the 10th of September. He's on page 7.
What date, Judge?
He's supposed to be on September 10th because they had an evaluation for him.
Okay.
Michael Mora? Hi, you're supposed to come back on September 10th. Okay. And then Mr. Ross, we're trying to find your file. And then if you all will call me when Mr. Barron's is ready.
Almost, Judge.
All right, court is calling 2024 CR 0736, State of Texas versus Gabriella Raquel Rubenchak. Could I have parties announced for the record for the state? Defense?
Robert Barron, on behalf of Kelly Green.
All right, and are you Miss Rubenchak?
Yes, Your Honor, I am.
Any objection to this attorney standing in for Miss Green?
No.
All right. Counsel, have you received all the discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Ms. Rubenchak, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it?
Yes, Your Honor, I did.
Can I have a stamp for a plea, please? Oh, no problem. All right, did you review the true bill of indictment?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the document entitled Court Admonishments with your attorney? Did you understand it?
Your Honor, I
Did you sign it in all the appropriate places?
did. Yes.
Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargaining agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than your bargain for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
She's been able to assist me in her defense, and I believe she understands the nature of the charges and proceedings against her and that she's competent in her plea.
All right, and do you believe she was sane at the time of the offense?
I do.
Ms. Rubenchak, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, there's a $500 fine to be probated. State recommends deferred adjudication. Did you understand that to be the plea?
Yes, Your Honor.
Defense is at the plea.
It is, Judge.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
There have not, Judge.
Outside the agreement, state is requesting that your deferred adjudication be for a term of 3 years. There be a TAP evaluation and 100 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
No objection.
All right, state, you may be excused. Did you review the document entitled Waiving Consent to Stipulation of Testimony and Stipulations with your attorney?
Yes.
Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
We'd like to, Judge, but they are recommending a tap, so I don't know how you want to handle that, given her
Oh,
situation here.
we can go for it.
All right.
All right, so, Ms. Rubencheck, how do you pronounce your last name? Rubencheck. All right, so what is this probation violation out of Collin County? What's happening with that?
To be honest, I have spoken to a previously hired paid lawyer.
I know, so here's the thing. I don't want you to get into the facts of your case. The only thing I want to know, and I'll take blame for that for not being direct. Is there a probation case, a motion to revoke, deferred adjudication, or community supervision that's still pending in Collin County?
Yes, Your Honor.
All right, and so what is that for? What's the charge? What are you on probation for in Collin County?
It's forgery, government money, and securities.
Okay. All right, so that means that, did you make bond on that case for the motion to revoke?
No, I have not.
All right, so there's probably a warrant for you and they're gonna need to take you to wherever they need to take you.
Yeah, I inquired earlier, but we apparently don't have the wherewithal to find out if there is indeed a hold, but I'm sure there probably is. And I tried to call the attorney that Ms. Rubencheck was referring to, and I haven't heard back from him.
All right.
So
I'm trying to figure out what would be the best. Because any type of program I put you in, they're not gonna accept you. Because you have that case that's pending from the other county. Do you have a court date for that?
As to my knowledge, I do not.
Just 1 moment.
I tried to look that up for you, Judge, and I had very little success with that. All I found was a case number.
So is your attorney in Collin County, is that a retained or appointed?
It's a paid lawyer, so I guess 15.
All right, who paid for your attorney?
I-
Did you pay them? We can go off the record. Because I'm just trying to figure out where that case is in the system. Did you pay for them when you were placed on probation, or did you hire them after a motion to revoke was filed?
I want to say it's been so long, to be honest. I want to say before I was placed on probation.
All right, so then you probably don't have an attorney. Just 1 second. Let's find out what's happening here. All right, so what's going on is we're gonna bring you back on the 22nd. Your attorney is gonna speak to, and we're gonna put a hold on you. Norma, make sure there's a hold on her in this system so they don't take her.
Okay. So should we have a-
No, we're not. We're gonna put a hold on you so that the other county won't come and pick you up. Your attorney here is gonna see if he can contact your attorney there. The reason why I'm calling this back for the 22nd, because any program I place you in to address whatever drug issues you may have and to address the fact that you're pregnant, they are not going to transfer you in any type of program, accept you in any program or treatment court while there are outstanding cases. And because that's a motion to revoke in another county, they count that as being an outstanding case. So that case needs to be taken care of before I can place you in programs here. So your attorney, who is not your attorney there, he's just going to do some investigation work to see what can happen with that case there, so we can give you the appropriate conditions here. So we're going to bring you back on July 22nd. If there's an issue where your attorney needs more time, he'll let me know. But that being said, we'll bring you back on the 22nd. Okay? All right, thank you. All right, so we will be back on the 22nd. But I'll be here Friday.